I opened the living room door at 12:47 a.m. The Reed family house in Beacon Hill had never kept the lights on at this hour unless something was wrong. The soft yellow glow from the floor lamp reflected on the old oak floor my grandfather once called the witness of 3 generations. I set my suitcase down as quietly as I could, but the wheels scraping against the wood still echoed dryly. Then I saw them. Clara was standing in the middle of the living room. My father, Edward Reed, had his arms around her. Not a polite embrace. Not a brief, comforting gesture. She rested her head against his chest, her hands placed behind his back, as if that was where she belonged. I stood motionless. Neither of them startled. Clara looked up at me first. Her eyes were red, but not the kind of red from sudden shock. The kind from crying long before I walked in. The house stood in Boston, on the stone-paved street of Beacon Hill, where everything smelled of money and tradition. My family had built Reed & Companies since the 1950s. My father always said family honor mattered more than profit. I believed that. I had believed in my family more than any contract I had ever signed. I was 38, managing the investment division of the company. Clara was 34, formerly in marketing before quitting after marrying me. My father was 68, recently in declining health but still controlling most of the shares through the family trust. We lived together because he wanted the family never divided. "Why are you still awake?" I asked Clara. My voice was calmer than I expected. "Dad wasn't feeling well. I was just here with him," she said. She did not step out of his arms immediately. My father looked at me as if I had walked in at the wrong time. "You're back earlier than expected." "The meeting ended quickly," I replied. No one explained why a daughter-in-law had to hold her father-in-law near 1 in the morning. No one explained why their eyes carried something beyond boundaries. I did not shout. I did not slam the table. I observed. In recent weeks, Clara had often accompanied my father to the bank. She said it was to help him remember appointments. His office had started being locked more often. The financial advisor no longer sent reports directly to me as before. I reassured myself they were minor changes in asset management. That night, when I stepped further into the room, Clara placed her hands slowly against my father's chest, as if to calm him, but her eyes stayed on me. In that moment, I understood what I was witnessing was not only intimacy, it was an alliance. "I'm tired," I said. "I'll go upstairs." No one stopped me. No one apologized. No one explained. I carried my suitcase past them, feeling the invisible but sharp distance among the 3 of us in that house. In the bedroom, I did not turn on the light. I sat on the edge of the bed and thought about everything I had signed in my life. $1-million contracts, investment agreements, complex deals. I understood law. I understood assets. I understood inheritance rights. And for the first time, I wondered whether I was being removed from what belonged to me. The next morning, Clara acted as if nothing had happened. She made coffee for my father. She asked if I wanted breakfast. She did not mention the night before. I did not look for evidence of an affair. I looked for signatures. I went down to my father's office. The file cabinet was locked. That had never happened before. I called Daniel Brooks, my personal attorney. "I want to review the structure of the family trust," I said. Daniel was silent for a few seconds. "There were recent changes," he replied. "What kind of changes?" "Trust restructuring. A portion of the shares has been transferred." "To whom?" "To Clara." I did not feel anger immediately. I felt cold. 60% of the shares, several real estate properties under the family trust, including the Beacon Hill house. The signing date matched the day my father had just been discharged from the hospital for heart complications. I requested copies of the documents. When I looked at my father's signature, I noticed the trembling stroke. Not the familiar signature of a man who once negotiated millions. That evening, I did not speak to Clara. I did not confront my father. I stood before the office window, looking down at the quiet street of Boston, and understood that this battle would not take place in the living room. It would take place in court. And I would not walk into it as a betrayed husband. I would walk into it as the lawful heir. I did not search for evidence of an affair. I searched for signatures. The next morning, as the Boston sun filtered through the tall windows of Reed & Company's headquarters, I arrived earlier than usual. The city outside moved as it always did. Taxis along Commonwealth Avenue, office workers rushing past corner cafes. No one knew that inside this glass and steel building, a quiet inheritance war had begun. Reed & Company stood in Boston's financial district, where old families protected their wealth with attorneys and clauses rather than emotion. I grew up among board meetings, thick contracts, and cold handshakes. I was taught that assets never shifted without strategic reason. And now, 60% of the shares had disappeared from their familiar position in the family trust. I sat at my desk and opened Daniel Brooks's email. He had sent copies of the trust restructuring documents. Clara Reed's name appeared under primary beneficiary and controlling interest holder. I read every line, every clause, every legal footnote. The documents had been drafted by a different law firm, not the long-standing firm of my family. That meant Clara had sought them out herself. Daniel entered my office at 9 a.m., placing a briefcase on the desk, his expression more serious than usual. "Malcolm, if we want to challenge this transfer, we need to prove two things," he said. "Lack of capacity at the time of signing, and undue influence." "I don't want a family war," I said, though I knew that no longer mattered. "This is no longer a family war. It's a legal issue." I asked Daniel to contact the family's former financial advisor. His name was Robert Hale, who had worked with my father for over 20 years. When we met him in a small conference room on the 12th floor, he avoided my eyes. "The restructuring happened quickly," he said. "Clara pushed the timeline, saying Edward's health was unstable." "Did you personally explain the clauses to my father?" I asked. "I was present at the signing, but Clara prepared everything." That answer was not enough to accuse, but enough to suspect. I requested the bank appointment records from the signing day. A bank employee confirmed Clara had scheduled a private appointment and requested a confidential signing room. When I reviewed my father's medical records, I saw he had been discharged 3 days before the transfer. Diagnosis: cardiac arrhythmia, with mild cognitive impairment noted. The medication could affect focus and judgment. I was not a doctor, but I understood enough to know the timing was not ordinary. That afternoon, I returned to the Beacon Hill house. Clara was sitting in the living room, scrolling through her phone. She looked up when I entered. "You're working late," she said evenly. "I reviewed the trust," I replied. She paused for a second, then smiled faintly. "You know Dad trusts me. He just wants everything stable." "Stable for whom?" I asked. She did not answer directly. "You're always busy. I'm the one here every day." The statement was delivered like a quiet accusation. I did not argue. I simply said, "I'll review all the documents." That night I sat in my office and opened every file. I searched for irregularities on the signing day. Time, signatures, witnesses. I noticed my father's signature on the original document did not fully match his usual signature on past contracts. The strokes trembled, spacing uneven. I called Daniel. "We're filing a petition for court review," I said. "Malcolm, once you file, there's no going back." "I know." The next morning we prepared the filing for Suffolk County Probate and Family Court. The petition requested nullification of the transfer due to suspected lack of capacity and undue influence. When I signed my name on the document, I felt a strange calm. Not anger, not pain, just decision. Before submitting it, Daniel asked, "Do you want to speak with your father one more time?" I thought of 1247. I thought of the embrace in the living room. I thought of Clara preparing documents and scheduling bank appointments. "No," I said. "If he wants to talk, he'll call me." Once the filing was submitted, everything became official. A legal notice was sent to Clara and Edward. I knew when they received it, the air inside the Beacon Hill house would shift. That evening, when I entered the house, my father was sitting in the dining room. The opened court envelope lay on the table. He looked at me longer than usual. "You're suing me?" he asked. I'm challenging the transfer, I replied. Clara stood behind him, her hand on his shoulder like an invisible reminder. Why are you doing this? She said. To know the truth. No one shouted. No one cried. But I saw uncertainty in my father's eyes. Perhaps he did not remember every clause he had signed. Perhaps he simply trusted the person closest to him. That night I returned to my office and looked down through the glass at the city. Boston was still lit. The financial towers stood silently, indifferent witnesses to power and assets. The battle had begun. And this time, I was not only protecting money, I was protecting my right to stand in my own family without being erased by a trembling signature. I sued my father. And I sued my wife. When that sentence formed clearly in my mind, I understood I had crossed a line with no return. The petition had been accepted at Suffolk County Probate and Family Court, and a preliminary hearing was scheduled just 3 weeks later. 3 weeks for my entire family to officially stand on opposite sides. Boston is not unfamiliar with inheritance disputes, but when the Reed name appeared on the public docket, attention was inevitable. A financial journalist called my office with a polite yet curious tone. I declined to comment. I did not want this matter turned into public entertainment. This was not a scandal to sell papers. It was a battle about rights and truth. The courthouse stood in the center of the city, where cold stone steps led into a space where emotion was replaced by evidence. When I entered the first hearing, I did not walk beside Clara. She arrived with her own attorney, a woman named Amanda Keller, specialized in trust litigation. My father walked more slowly than before, leaning on a cane, his eyes not meeting mine. I sat beside Daniel. In front of us lay thick stacks of documents, including medical records, copies of emails, bank appointment logs, and signature analyses. I did not look at Clara. I focused on Judge Helen Carter, who would decide whether the case had sufficient grounds to proceed to full trial. Amanda stood first. She argued that the trust restructuring was entirely lawful, that Edward Reed possessed full legal capacity at the time of signing, and that Clara had merely fulfilled a supportive family role during a difficult period. She implied that I, Malcolm Reed, was a busy son, frequently traveling for work, and not present enough to care for my father. I listened without reaction. Yes, I traveled often. Yes, Clara was home more than I was. But presence is not power of attorney. Daniel rose. He did not raise his voice. He presented concisely. The signing date coincided with Edward's recent hospital discharge. Prescribed medication could affect cognition. The transfer had been arranged by Clara and a new law firm, and the signature displayed irregularities compared to prior exemplars. The judge addressed my father directly. Did you fully understand the contents of the transfer at the time of signing? My father looked down at the table. I trusted Clara, he said. She said it was good for the family. Did you read each clause? I trusted. That answer lingered in the courtroom. Trust is not evidence, but it is not guilt either. Amanda countered. She presented emails between my father and me in which I declined a doctor's appointment due to a meeting in New York. She emphasized that Clara was the only one consistently present. She painted the image of a devoted wife and a distant son. I did not argue with emotion. I spoke only when asked. I do not object to Clara supporting my father. I object to lawful inheritance rights being altered without transparency and full capacity. The judge ordered detailed medical records to be reviewed and allowed an independent cognitive evaluation regarding capacity at the time of signing. She also required the original documents for expert signature examination. The hearing adjourned, but I knew it was only the beginning. As we exited the courtroom, footsteps echoed along the long corridor. Clara walked past me without speaking. The familiar scent of her perfume passed like an unwanted memory. My father paused near the exit. You didn't have to do this, he said quietly. I need the truth, I replied. Don't you trust me? I trust evidence. He looked at me for a long moment, as if trying to recover something lost between us. Then he turned away. In the days that followed, newspapers began publishing brief reports about the internal dispute within the Reed financial family. I did not read them fully. I focused on the file. Daniel informed me that Clara's side had filed a motion to dismiss for lack of sufficient grounds. That meant we had to present stronger, specific evidence. I worked with a forensic handwriting expert. He pointed out differences in pen pressure and writing rhythm. Not enough to declare forgery, but enough to question steadiness and fine motor control. I also obtained bank surveillance footage from the signing day. The footage showed Clara speaking with bank staff for an extended time before my father was brought into the signing room. In one short clip, my father asked, "What are we signing?" Clara replied, "Just updating paperwork, Dad." The video did not prove everything, but it revealed ambiguity. As Daniel and I prepared for the next hearing, he asked me bluntly, "If the court declares your father fully competent, will you accept it?" I looked out the office window as Boston's city lights began to glow at dusk. "If that is the truth, I will accept it," I said. "But I will not accept a decision built on ambiguity." That night, I returned to the Beacon Hill house again. The air inside felt heavier. Clara was in the living room, my father in the dining room. No one spoke to me. I walked upstairs, each wooden step sounding like the separation widening between us. The legal battle had fully formed. No longer personal suspicion, no longer wounded emotion. It had become a file, a case, a chain of evidence. And I knew that from this moment on, my family would never return to what it once was. The courtroom has no emotion, only evidence. When I entered the formal hearing at Suffolk County Probate and Family Court, I understood that from this moment forward, everything would be measured by documents, testimony, and records, not by memory or feelings of betrayal. The Boston morning was colder than usual. The stone steps leading into the courthouse were damp with mist. I walked beside Daniel, speaking little. He had prepared a thicker file than before: forensic signature analysis, independent medical evaluation, and officially extracted bank footage. I no longer thought about 1247. I thought about each line that would be read before the court. Inside the courtroom, Clara sat beside attorney Amanda Keller. She wore a light gray suit, discreet and professional. No clear emotion on her face. My father sat one row behind her, back slightly curved, hands folded together. I did not know what he was thinking, or whether he remembered why we were here. Judge Helen Carter entered. The air shifted immediately. No more murmurs, only anticipation. Amanda presented first. She reaffirmed that the trust restructuring was a lawful decision by Edward Reed. She emphasized that Massachusetts law does not prohibit a father from transferring assets to his daughter-in-law if he believes it benefits the family. She also argued that mild cognitive decline does not equal legal incapacity. I listened without objection. Yes, the law does not prohibit it, but the law requires understanding and voluntariness. Daniel rose. He did not attack Clara. He focused on principle. "Your Honor," he said, "the issue is not whether Mr. Edward had the right to transfer assets. The issue is whether he had sufficient cognitive capacity and full understanding of the legal consequences at the time of signing." Dr. Richard Halpern was called to testify. He was an independent neurologist appointed by the court. He stated that at the time of signing, Edward was taking medication that could impair concentration and affect the processing of complex information. Records indicated short-term memory impairment. Amanda asked, "Can you confirm Mr. Edward was entirely incapacitated?" "No," the doctor replied, "but I can say his ability to assess risk and understand complex legal documents may have been significantly impaired." The phrase "significantly impaired" echoed in the courtroom. Next came the forensic handwriting expert. He presented differences between prior contracts and the transfer document signatures. Variations in pen pressure, writing rhythm, and line stability suggested unusual tremor. Amanda argued that aging can alter a signature. That was true. But Daniel pointed out that the change occurred abruptly during the same period as the hospital discharge. Then the bank footage was played. The room dimmed as the screen lit up. Clara was seen speaking with bank staff for nearly 15 minutes before my father was brought into the signing room. My father sat down. He picked up a pen. In the faint audio, he asked, "What are we signing?" Clara responded, "Just updating paperwork, Dad." No detailed explanation was heard afterward. I did not look at Clara when that clip played. I looked at my father. He did not lift his head. The judge addressed him directly. "Mr. Edward, do you recall reading the entire document before signing?" He hesitated. "I believe," Clara explained. "Do you recall the specific content?" He remained silent for several seconds. "Not completely." That silence lasted longer than any accusation. Amanda attempted to redirect. She said trust within a family is normal, that no one forced Edward. There was no evidence Clara threatened or deceived him. But Daniel emphasized that undue influence does not require overt threats. It can exist within emotional dependence and vulnerability. I was called to testify. I spoke about not being informed of the trust changes. I spoke about financial reports being cut off from me. I did not discuss emotion. I discussed process. Amanda asked me, "Are you angry because your father trusted your wife more than you?" "I am not here because of emotion," I replied. "I am here because of legal rights." The hearing lasted for hours. At the end, the judge declared there was sufficient basis to proceed with full consideration of undue influence and cognitive capacity at the time of signing. She did not issue a final ruling, but she did not dismiss the case. As we left the courtroom, I felt a shift. Not victory, not yet. But ambiguity had begun to give way to legal structure. Outside the courthouse, the Boston air felt colder than in the morning. Clara walked past me. Her eyes were no longer as confident as before. "Do you really want to undo everything?" she asked quietly. "I want the truth," I said. My father stood behind her, leaning on his cane. He looked at me as if trying to recall something that had slipped from his memory. I walked down the stone steps of the courthouse, understanding that this battle had moved from suspicion to evidence, from family to file, and from trust to law. Justice does not arrive in an explosive moment. It comes step by step, through each question, each answer, each long silence in the courtroom. And I knew that when the next session began, there would be no room left for ambiguity. News does not ask who is right. It asks who is winning. I understood that the morning my name appeared on the front page of a local Boston financial section. The headline was not sensational, but it was clear enough. "Reed heir sues father and wife in trust dispute." They did not need adjectives. Placing our names side by side was enough to create a story. Reed & Company had always prided itself on discretion. My family built its reputation on stability, not scandal. But in Boston's financial world, everything spreads quickly. Calls began coming into my office more than usual. One partner asked whether the lawsuit would affect the company's control structure. A longtime investor requested a private meeting to clarify the situation. I did not hold a press conference. I did not issue a public statement. I sent a brief internal memo. Company operations remain unchanged. The legal dispute is personal and does not affect current management. I chose each word carefully. Every sentence had to be precise, without emotion. That afternoon, Daniel informed me that Clara's side had filed a motion to suspend my voting rights pending trial. The reason? To avoid conflict of interest. I looked at him for a few seconds. "She's preparing for the worst-case scenario," I said. "And so are we," Daniel replied. We immediately filed an opposition, requesting the court maintain the current governance structure until final judgment. Meanwhile, the press continued digging. They revisited company founding records from the 1950s. They referenced major deals I had signed. They painted a picture of a financial family fracturing from within. That evening I returned to Beacon Hill and found Clara sitting in the living room with a laptop open. When I entered, she closed it. "You're destroying the family's reputation," she said. "I'm protecting my lawful rights," I replied. "Do you think the press will take your side?" she asked. "I don't need them to." She stood and stepped closer. "Do you know what people are saying? They say you're greedy. They say you're suing your own father for money." "I'm not suing for money," I said. "I'm suing over a signature." She gave a faint smile, without warmth. You really believe the court will undo everything over a few doubts?
I believe in evidence.
The conversation ended there. No direct accusations, no hidden intimacy like the night at 12:47. Instead, a coldness, like two strangers living under the same roof. In the following days, I began to feel isolation forming. Some board members avoided eye contact in meetings. They did not say it, but I knew they were worried. Stability is the greatest asset of a family company, and now it was being questioned. Daniel proposed a strategy. We should request a temporary asset freeze on what Clara controls, to prevent transfer or sale of shares during litigation.
Will the court grant it?
I asked. If we show risk of structural change, yes. We prepared the motion. The argument was based on the fact that control was disputed, and any action could cause irreparable harm. I signed without hesitation. I could not allow family assets to continue shifting while their legality remained in question. The emergency hearing occurred sooner than I expected. Amanda objected, stating Clara had no intention of selling shares. But Daniel argued that control had already changed significantly, and the risk could not be ignored. The judge issued a temporary order freezing asset transfers until final judgment. When the decision was read, I did not feel victory. I felt the distance between Clara and me formally acknowledged by the court. After the hearing, a reporter in the hallway asked, "Do you regret bringing this to court?" "I do not regret demanding transparency," I replied. That night, inside the Beacon Hill house, no one spoke. My father sat in the dining room, staring at the newspaper on the table. I did not know how much he read, or how much he understood. Clara was in a separate bedroom. The door was closed. I sat alone in my office, looking through the window at the quiet street. Boston remained lit, as if the city did not care about the fractures inside this house. I thought about reputation, legacy, and the things my father once said about family always standing together. But a family cannot stand together if its foundation is ambiguity. The battle was no longer confined to the courtroom. It had spread into public view. And I knew from this point forward, every step I took would be observed. Isolation does not arrive with noise. It arrives in the silence of those who once stood beside you. And I accepted that. Emotions can lie. Medical records do not. I repeated that sentence in my mind as I entered the next hearing at Suffolk County Probate and Family Court. The media was still outside, but inside the courtroom, the atmosphere had changed. Fewer murmurs. People were waiting for something more concrete. The independent medical evaluation. Dr. Richard Halpern sat in the witness seat, a thick file in front of him marked with notes in different colors. I did not look at Clara when I sat down. I looked at the documents prepared over weeks. If there was a place where truth was not distorted by emotion, it was within clinical pages. Daniel began by asking the doctor to confirm the evaluation process. The doctor explained that he had reviewed Edward's complete medical records for 6 months before and after the signing date, including prescriptions, nursing notes, and standardized cognitive assessments. He had also personally interviewed Edward at the court's request. Amanda objected lightly, noting the interview occurred months after the signing and did not perfectly reflect his condition at that time. The judge allowed continuation, but emphasized focus on contemporaneous records. Dr. Halpern began presenting. He stated that at the time of signing, Edward was prescribed medication for arrhythmia and anxiety. Some medications could impair concentration, slow information processing, and affect short-term memory. Treatment notes indicated the patient occasionally confused dates and appointments. Daniel asked, "Under such conditions, could the patient fully understand a complex legal document involving multiple asset transfer clauses?" The doctor replied, "He might understand portions if clearly explained and repeated. But his ability to independently read and evaluate the full legal consequences could have been significantly impaired." I felt that answer as a foundation, not a declaration of total incapacity, but acknowledgement that understanding may not have been complete. Amanda stepped forward. "Do you have evidence that Clara intentionally concealed content?" "No," the doctor said. "I offer no opinion on motive. I evaluate cognitive capacity." The hearing revolved around the word capacity. Not feelings, not morality, only ability to understand. Daniel then presented a nursing discharge note stating, "Family required repeated reminders regarding medication schedule." This suggested dependence on a caregiver. Clara sat still, hands clasped. I could not read her thoughts. Perhaps she believed she had done the right thing. Perhaps she believed I was the one who betrayed the family. Next came the replay of the bank recording, this time with clearer audio extraction. My father's voice was more distinct than before. "Does this document affect Malcolm?" Clara replied, "No, it's just to keep everything safe." My father had thought of me. He had asked about me. The judge made a notation on her pad. Amanda argued that the word safe did not imply deception. But Daniel emphasized that if Edward believed signing did not affect me, then his understanding of the legal consequences might have been incomplete. When called for additional questioning, my father spoke slowly. "I trusted Clara," he repeated. "I thought she was helping the family." "Did you know the transfer altered your son's inheritance percentage?" the judge asked. He looked down. "I do not clearly remember." I did not feel anger hearing that. I felt emptiness. Not because he did not remember, but because perhaps he had never been fully informed. The hearing lasted until late afternoon. At the close, the judge stated that medical and audio evidence would be considered alongside other materials before ruling on undue influence. As we left the courtroom, Daniel spoke quietly. "The medical record helps build structure, but the final decision still rests with the judge." "I understand," I replied. Outside the courthouse, Boston wind blew stronger. Reporters waited, but I did not stop. I walked down the stone steps, thinking of what my father once taught me. Read every clause before signing. Understand every consequence before putting pen to paper. Perhaps he had forgotten his own advice. Or perhaps he believed the person beside him would never take advantage of that trust. That night, when I returned to Beacon Hill, the house was unusually quiet. Clara was in the bedroom. My father sat in his old office staring at an open file. I did not know what he was reading. "What did the court say?" he asked without lifting his head. "The court will review the medical records," I said. He nodded faintly. "Do you think I wasn't of sound mind?" "I think you deserved protection from decisions made when you were not at your strongest." He did not respond. I stood there for a few seconds, then left. In my office, I looked out the window at the street. Boston moved as usual, but inside this house, everything was under a microscope. Medical records do not lie, but they do not comfort. And I knew that when the final hearing came, those pages would decide not only assets, but what remained between my father and me. Not the lawyers, not the media, not the recordings or medical files. In the end, my father would decide everything. When the final arguments began at Suffolk County Probate and Family Court, I understood that every legal structure, every document prepared over months, would converge into one thing: his testimony. Boston was more overcast than usual that day. A gray sky reflected through the tall courtroom windows. Fewer reporters attended. The story had lost its novelty. But for me, this was the most critical moment. Clara sat beside Amanda, back straight, hands resting on the table. I did not look at her. I looked at my father as he stepped onto the witness stand. He moved slowly, his cane tapping lightly with each step. I wondered whether he fully understood the consequences of what he was about to say. Judge Helen Carter began by restating that the court was examining two elements: cognitive capacity at the time of signing and the potential existence of undue influence. She instructed Edward to answer directly and clearly. "Mr. Edward," she said, "on the day of the transfer, did you believe it did not alter your son's inheritance rights?" My father looked up, tired but not evasive. "I believed everything would remain stable," he said. "Were you informed that 60% of the shares would transfer to Clara?" He paused. "I remember something about protecting assets." "Did you understand that the transfer could remove Malcolm's control?" He gripped the edge of the stand. "I do not clearly remember." That answer was not a confession, but it was not certainty either. It existed in between, where the law must intervene. Amanda stepped forward. She asked my father whether anyone forced him to sign. He shook his head. "No one forced me," he said. "Did you believe Clara wanted what was best for the family?" "Yes." Those answers complicated everything. There was no overt coercion, no threats, only trust. Daniel approached for final questioning. "Mr. Edward," he said, "if you had known that signing would alter Malcolm's inheritance percentage and grant controlling interest to Clara, would you have signed?" The courtroom fell silent. I could hear the clock ticking behind us. My father looked at me. For the first time in months, he looked directly at me. "I don't know," he said slowly. "Perhaps I would have asked again." That answer pierced through every layer of defense. Not because it confirmed anything, but because it admitted uncertainty. The judge called for order and wrote notes longer than usual. I was permitted a brief statement. I had not prepared a speech. I spoke plainly. "I am not here to accuse my father," I said. "I am here because any decision that alters inheritance structure and asset control must be made under full transparency and complete understanding. If he does not remember, if it was not clearly explained, then that is not complete consent." I did not look at Clara as I spoke. I looked only at the judge. Amanda concluded by emphasizing that trust is not evidence of undue influence. She argued that if a transaction could be voided merely due to memory hesitation, any agreement involving an elderly individual could be challenged. Daniel responded that this was not mere hesitation. It was a combination of medical records, bank audio, and uncertain testimony regarding legal consequences. The hearing concluded. The judge stated she would review the full record and issue a ruling promptly. No applause, no outburst, only waiting. As we left the courtroom, Clara paused behind me. "You think because he's weaker now, you have the right to decide for him?" she asked. "I think the law must protect decisions made in vulnerable circumstances," I replied. My father walked past us. He stopped. "Malcolm," he said, "no matter what, I am still your father." "I know," I answered. But that statement did not erase what had happened. That night, I sat alone in my office at Reed & Co. Boston moved outside, city lights reflecting against the glass. I thought about my father's words. Perhaps I would have asked again. Perhaps. In law, perhaps is not enough. A signature must rest on certainty. A transfer decision must rest on clear will. I did not know how the judge would rule. But I knew that in today's hearing, ambiguity had been exposed publicly. And when ambiguity enters a courtroom, it is no longer shielded by family affection. It must face the law. Justice does not cheer. It does not stand and applaud. It does not cry. It is simply read aloud, sentence by sentence, in an even and steady voice. When I entered the final judgment session at Suffolk County Probate and Family Court, I did not feel the tension I had before. I felt quiet. Boston that morning was cold and clear. The pale blue sky reflected off the stone steps leading into the courthouse. Fewer reporters were present than in the early weeks. The story had become a dry legal file in the public eye. But for me, this was the moment that would redefine everything. Clara sat on the left side of the courtroom beside Amanda. She did not look at me. My father sat behind her, back straighter than in previous sessions, though his eyes still carried fatigue. I did not know what he expected. Perhaps he still believed everything could return to the way it was. Judge Helen Carter entered. The room stood and sat. She opened the thick file before her, adjusted her glasses, and began reading. She summarized the entire process: medical records, cognitive evaluation, signature analysis, bank audio, testimonies from all parties. Her voice was steady, without emotion. Each element placed into logical structure. "Regarding cognitive capacity," she said, "the court finds that at the time of signing, Mr. Edward Reed was under medical treatment capable of impairing his ability to process complex information." I did not look at Clara. I did not look at Daniel. I only listened. "Regarding undue influence," she continued, "the court determines that although no evidence of direct coercion exists, the The dependence on a caregiver and lack of transparency regarding legal consequences created a significantly vulnerable environment. I heard the scratch of someone's pen behind me. No one spoke. Therefore, the judge stated, the court declares the transfer of 60% of shares and related assets null and void. Control rights and inheritance structure are restored to their status prior to the signing date. No sigh of relief, no loud murmuring, only a silence that lasted several seconds. The temporary asset freeze shall be lifted upon completion of restoration. The transferee holds no authority to undertake further control actions regarding these assets. She closed the file. Court is adjourned. That was all. Daniel lightly placed his hand on the table. We won, he whispered. I did not answer immediately. I looked at Clara. She sat still, her eyes no longer sharp, only tired. Amanda leaned in to say something to her. My father stared at the floor, as if he had lost something, or been freed from something. I stood and walked out of the courtroom. No one stopped me. No one called my name. Outside the courthouse, sunlight struck my face. A reporter approached, but Daniel signaled no comment. I descended the stone steps, each step steadier than the last. I did not return to Beacon Hill immediately. I went to Reed & Company and instructed the legal department to begin restoration of voting rights and update governance structure. No celebration, no champagne, only work. That evening, I returned to the Beacon Hill house one last time as the restored, lawful heir. Clara had packed her belongings. A suitcase stood by the door. She did not look at me as she passed. You got what you wanted, she said. I got what was mine, I replied. She paused for a few seconds, then left. My father sat in the dining room. The newspaper that day did not mention the ruling. The story was no longer compelling. He looked at me. Are you satisfied? He asked. I didn't do this for satisfaction, I said. I did it because it was necessary. He nodded slowly. I don't clearly remember everything that day, he said, but I remember that I trusted. I know, I replied. We sat in silence for a long time. No apology, no immediate reconciliation. Only acknowledgement that a decision had been corrected by law. But the fracture within the family would take time to understand. A few weeks later, I sold my personal interest in the Beacon Hill residence and moved out. I did not want to live in a space that had become evidence. I established my own investment fund, separate from the family structure, while retaining my lawful inheritance. On the final night before leaving, I stood in the living room where everything began at 12:47. The yellow light remained the same. The wooden floor still reflected shadows. She cried in my father's arms, but she did not cry when I left. And justice did not cry either. It simply stood still, cold, and exactly where it belonged.